So, we got a little bit of a treat tonight. This is Randall Keith Bean's appeal. Should do a little intro explaining who Randall Keith Bean is. I'm pretty sure if you're watching this, you know who Randall is. Anyway, Randy is, or was, a sovereign citizen that got mixed up with HATJ and got mixed up in the TDA account stuff and is currently in jail for 13 years. And he's appealing his case. Now, I want to draw attention to something because this sort of indicates a sort of behind-the-scenes drama that is going on right now. Randy filed his appeal December 5th, 2018. That was about 3 months ago. And I was not checking Randy's case file, because I assumed that IUV would be posting the appeals when they were made. Turns out, not the case. Randall's appeal has been kept secret for the last 3 months. I had to download it and pay for it myself. And the reason why Randall's appeal is being kept secret is going to become very obvious as we read it. And it is because it is not good to the, let's say, it goes contrary to the narrative that Heather's followers in IUV, etc., are trying to portray. Interestingly, Randall has gotten himself a pretty good attorney here. Notice, again, he is no longer relying on Heather. He's actually got a full law clinic working on his appeal. These people are apparently good lawyers. It looks like a very solid appeal, but I'm not a lawyer, so that might be wrong. But it does look like a good appeal. As we can see here, the summary of the arguments here is that Bean should not have been allowed to represent himself in the trial court because A, Bean was not competent to represent himself. The standard for competency is more stringent. Bean's conduct signaled that he was incompetent. Bean's conduct after the hearing signaled his incompetence. And Bean's conduct during the trial signaled his incompetence. And B, this is a spicy part, Bean's self-representation was particularly inappropriate when his co-defendant and alleged co-conspirator was his former attorney. Here, that part of the argument, Randy is placing blame for the guilty verdict on Heather. Anyway, so you can see how serious this is. This is all the cases that they're relying on. There's 3 pages full of case law that they're citing and some statutes, which we're not going to get into. Here we go. I am the source of all that is, Randall Bean told the court, and with that startling self-identification, his Feretta hearing began. Feretta hearing, blah, blah, blah. When Magistrate Judge Shirley followed up and asked Bean whether he was God, Bean replied again, I am the source of all that is. In response to the magistrate asking whether Bean was the source of the sun and moon, Bean replied for the 8th time, I am the source of all that is original. Despite all this and more, the magistrate somehow found Bean competent to represent himself at trial, and the district judge did nothing to revisit that finding. This appeal is about the catastrophic consequences of letting a man subject to such beliefs defend himself in a high-stakes criminal trial where decades of imprisonment were on the line. Bean requests oral argument of this appeal because it involves fundamental constitutional... Actually, let me emphasize this. This is Bean making this request via his attorneys. Some of the spin that has happened with HATJ claiming that she is mentally ill is that it's the lawyer doing it and they have nothing to do with it. That is simply not true. Bean is calling the shots here. Heather's calling shots in her appeal. Anyways, Bean believes that counsel's discussion of these issues with the court will aid this examination of the merits, because Bean represents himself in the court below. He's never had the benefit of counsel defending his interest. This appeal represents a meaningful opportunity for that to happen. Here they restate the central issue. whether the trial court erred in granting Bean's request to proceed pro se and in failing to revisit that decision in the appeal in the face of Bean's repeated demonstrations throughout every stage of the proceedings below that under any objective standard he was incompetent to represent himself, especially at a joint trial where he was subject to being unduly influenced by his alleged co-conspirator, in this case Heather and HATJ draft. Here we have a summary of the case. On July 18th, Bean was indicted on 5 counts of wire fraud, 1 count of bank fraud, 1 count of conspiracy to commit money laundering. Heather and HATJ draft was indicted as Bean's co-conspirator in the money laundering conspiracy after a jury trial at which Bean and HATJ both represented themselves. The defendants were convicted on all charges. Bean was sentenced to 10 years imprisonment for wire fraud, 12 to 13 years for bank fraud, and 12 to 13 years for conspiracy to commit money laundering. This appeal followed. Going over the facts here. In the summer of 2017, Bean sought deferment on several of his loans from USAA Bank, which declined his request. Seeking solutions, Bean watched Harvey Dent's video on YouTube, Pay Bills Now Using Your Secret Account. The video informed Bean that the Federal Reserve Bank was in possession of his money and kept it in a secret account. Blah, blah, blah. With this new information, Bean set up an account at the Federal Reserve. This is incorrect. But anyways, whatever. According to YouTube video's instructions, the account possessed 2 numbers for wire transactions, a routing number unique to the Federal Reserve, and an account number that matched Bean's social security number. And there's a little footnote saying that Harvey Dent appears to be the presenter's pseudonym drawn from the well-known Batman comics character of the same name. In the video, Dent welcomes viewers to the intellectual freedom movement and describes the movement's unique set of beliefs. Anyways, they go on. Bean used this new account number to retrieve money from what he believed to be his account at the Federal Reserve and used the funds to pay his credit card debt. Following this initial success, well, not really success because those transactions failed, Bean created a second account with the Federal Reserve and organized his account as a trust using his social security number, again, changing 1 digit. Through this account, Bean... there's some errors here. Okay, but he didn't create... the second account wasn't created with the Federal Reserve, but... Anyway, here we go. Bean liquidated these certificates of deposit after a bank agent informed him that liquidating only incurred a small fee, and he placed the cash in his account at USAA Bank. Bean made 2 significant purchases with this money. First, using a personal check, he bought a car for $86,000. Second, he bought a motorhome for $500,000 from Buddy Gregg. He paid for the motorhome, executing a wire transfer. Throughout these events, HATJ draft counseled Bean. She insisted there was dirty dealing at USA Bank and urged Bean to title his motorhome in the name of the trust rather than his personal name. In addition, HATJ draft publicly held herself out to be Bean's attorney. She created and signed documents for a factualized trust and Bean's lawyer, and she ensured that her name appeared on the deed to Bean's motorhome as his attorney. That's an angle that I was aware of. Heather essentially owned half of the motorhome, so she did have a financial motive to lie and do all this stuff. Anyway, HATJ draft also represented herself as Bean's attorney, as Bean's lawyer, while she was on a call with Lauren Palmasino, an employee at Whitney Bank. Perhaps most significantly, after Bean attempted to take possession of his motorhome and was arrested, HATJ draft repeatedly told law enforcement officers present at the scene that she was Randall Bean's lawyer. Transcript, blah, blah, blah. Despite HATJ draft's effort with law enforcement, Bean was indicted on federal wire fraud and bank fraud charges. He was indicted as well on a charge of money laundering conspiracy. HATJ draft was indicted as Bean's co-conspirator in that conspiracy, which was alleged to have begun on or about July 2017. The month after their indictment, Bean and HATJ draft asserted their rights to self-representation. The record does not indicate how Bean, a non-lawyer, learned of this right. HATJ draft, who had legal training, was presumably fully aware of it, though. As a first step in exercising his right to represent himself, Bean filed a motion seeking the removal of his court attorney appointed counsel, Bobby Hudson. Motion, that's a document that's signing. District Judge Marlin was assigned to Bean's case, and he referred the preliminary matters in the case to be handled by a federal magistrate judge. Shirley scheduled a Ferretta hearing to determine whether Bean wanted to waive his Sixth Amendment right. Now we can skip this. At the Ferretta hearing, Bean and Shirley came to an impasse almost immediately. The trouble began when Bean supplemented his own version of the oath to be sworn in, stating, "Standing due identification correction, I am source of all that is, original nunc pro tunc praetera, and I do swear to speak only true, accurate, and complete." This conversation quickly devolved when the magistrate asked Bean to elaborate on the meaning of this oath, leading him to ask if he was the source of the Kleenex box, and to state that his guess was that they'd have another hearing on this. At this time, Hudson asked the court for a few minutes to counsel Bean on the implications of his decision to not provide the normal oath. Knowing that Bean was interested in having the detention hearing, Hudson used this information to move Bean to changing his oath at the last minute. After this recess, Bean acquiesced and took the traditional oath. During the hearing, Shirley expressly questioned Bean about his understanding of self-representation. While doing so, the magistrate indicated that Mr. Hudson seems to think that Bean might have a different idea of what self-representation means from what Hudson told Bean it meant. Assistant United States Attorney Davidson elaborated, indicating that she seemed to think Bean might be of the notion that his co-defendant in his case, Ms. Tushy Draft, might be able to represent him. The magistrate assured Bean that she cannot. Despite the foregoing red flags, Shirley subsequently granted Bean's request to remove Hudson and proceed pro se, memorandum order, blah, blah, blah. The magistrate granted a similar motion for Tushy Draft and appointed elbow counsel to both defendants at the trial. In his order granting both Tushy and Bean's motions to proceed pro se, Magistrate Shirley admonished Bean that he could not have Tushy represent him, and similarly admonished Tushy Draft that she could not represent Bean. The magistrate's order nowhere even mentioned Bean's strange testimony at the Ferretta hearing. The Precipice hearing, this is where I like this part. Shortly after becoming his own counsel, Bean filed several motions. He supplemented his filing original due declaration of addendum of law, presumption, and perpetuity, due cancellation of true bills supplement with Randall Keith Bean signature. He filed a request for due identification, Finally, he filed an original instrument canceled true bill, Bean also filed some motions jointly with his co-defendant, including a precipice to enter dismissal. The precipice was the foundation upon which he and Tushy Draft built the defense that the court had no jurisdiction over them. The precipice was obviously Tushy Draft's initiative, since Bean could not explain the precipice to dismiss or his legal basis for claiming that the court had no jurisdiction over him. During the hearing before the magistrate, Tushy Draft alleged that the United States was a corporation that had been terminated. Because the United States had been foreclosed upon, she alleged the district court had no authority to exercise jurisdiction and did not exist. Therefore, the precipice argued any action taken by the United States prior to March 18, 2013 was legally void and unenforceable because on that day, the United States corporation had been terminated. As a result, the precipice said that the court did not have jurisdiction over the co-defendants. During the hearing, Magistrate Shirley asked Bean if he knew what a precipice was and whether he could explain the legal basis for his claim that the court lacked jurisdiction. The court immediately called attention to Bean's inability to answer either question. And although Tushy Draft argued with the magistrate at length about various legal issues she believed the precipice addressed, Bean spoke very seldom. Instead, he largely accepted and adopted Tushy Draft's statement. At one point, Bean asked Shirley why he could exercise authority over Bean if he was not God, and why he had not provided the co-defendants with proof of his existence. Ultimately, the magistrate recommended and the district judge approved an order striking the press debate from the record. Bean and Tucci were thus unable to raise their jurisdictional point as a defense in trial. In the course of this recommended ruling, Shirley expressly noted that the defendant's claims defy common sense. The magistrate report contained no reference to Bean's disturbing questioning of him about God at trial, or how that might reflect on Bean's competence to represent himself at trial. Varlin similarly indicated that the court is frankly unclear what these objections mean. Presentation of evidence at trial. Bean and Tucci Giraffe's close relationship continued throughout the proceedings. At trial, Tucci Giraffe introduced evidence on particular issues, and Bean did not supplement her introduction of evidence. Tucci Giraffe professed to have extensive knowledge of legal issues as well. She was able to engage in oral argument and discussion with the lower court, appeared to have a working command of the Uniform Commercial Code, and possessed some limited knowledge of legal trust and the process of criminal adjudication. Bean, on the other hand, was not able to do so because he had no legal training. Bean and Tucci Giraffe both testified at trial and continued to make confusing and frankly nonsensical assertions. During his testimony, Bean explained that one of the things he learned at some point was that his birth certificate was actually a trust account held in trust, a strawman account. He added subsequently that even if his birth certificate did not have value to him, it must have value to someone else because it was printed on bank bond paper. When asked about his actions, Bean responded that he relied on Tucci Giraffe for legal counsel on the issue, which wasn't supposed to happen. According to speaking with Tucci Giraffe, she said that was the best way to do it, so I was just trusting that was the correct way to do it, and it made sense when what she explained to me. Bean testified that he was enamored with Tucci Giraffe and believed he had much to learn with her. During her testimony, Tucci Giraffe asserted that one of her big family friends was actually the head of all the National Guard. As we talked about during the transcript, there is no head of all the U.S. National Guards, so she was familiar with the birth certificate theory. She claimed to be a high-level intelligence official, she's not, who was involved with Bean, and this case was part of her official investigation of the theft scheme that the Federal Reserve and its member banks concocted by using unknown and unsuspecting American citizens. Despite the irrationality of these assertions and their interdependence, and at no point during the presentation of evidence did Varlin raise any question about the competence of these defendants to be representing themselves before the jury. Closing arguments. Gets better. Bean's closing arguments demonstrated the same theme that he and Tucci Giraffe had espoused throughout the trial. He continued to insist that he was seeking to access to his own account with the Federal Reserve, and he implored the jury to believe that these accounts do exist and they do belong to us. From Bean's perspective, the only reason these accounts had not been publicly acknowledged was failure of others to use the correct verbiage to prove it. He urged the jury that his conduct was the result of his duty as an informed American and sincere living man. Bean did not limit his claims to the Federal Reserve. He claimed that the federal government was a morally corrupt and bankrupt institution that colluded with a corrupt financial institution, which had been proven to be corrupt through the mortgage crisis, the LIBOR scandal, and the bank bailouts. He asserted that his reason for not presenting a single objection throughout the government's case is to see exactly how long the government was willing to go in a continuous scheme to hide the truth from the people and perpetuate a system of slavery. Bean claimed that his scheme was so pervasive that the government murdered John F. Kennedy because of Kennedy's efforts to expose it. Bean explained to the jury that a book, Creature from the Jekyll Island, detailed description in its exception, goes fully into his conspiracy theory beliefs. He stated that the federal government created a secret banking system with the intent to exert control over the American people. Invoking the Bible, he begged the jury to take a stand with him. Claimed that he was kidnapped and assaulted by federal agents. He concluded by explaining that this trial was merely another piece of the grand scheme to put him away. Bean's entire closing argument concerned an elaborate scheme that had nothing to do with the specific elements of the crime with which he was charged. Tushy Giraffe's closing argument largely echoed the many difficult-to-believe themes she had raised throughout the course of the proceedings, as discussed above. She told the jury that inside these defense evidence filings, you'll see everything, all the laws, everything we went through to be able to secure, and we secured it, took it back, secured it. The same way it was taken, a reversal. The prosecution agreed the jury should review these filings because they do not say what they say. They do not say what she says they say. There is no support for a secret account. These were all filed at the Register of Deeds in Washington, D.C. That's where they're filed. They have a whole bunch of misuses of legal terms and gobbledygook. That's what these documents have. In her rebuttal closing argument with reference to Giraffe, prosecutor Davidson, she told the jury she would have you believe that she totally believes this, and it's maybe she's crazy. Davidson then directed the jury to not accept such a conclusion. Neither of these defendants are crazy, they don't believe what they're saying, and both defendants are guilty. Despite the incredible nature of the defendant's closing argument and the prosecution's express argument against the jury considering them crazy, the district judge did not revisit the competence of Bean or Tushy Giraffe. Jury verdict. After less than 4 hours of deliberation, the jury found Bean and Tushy Giraffe guilty as charged on all accounts. Summary of the argument. Under any objective view of the record, Bean should not have been allowed to represent himself, given his strange personal beliefs, his demonstrated inability to respond to simple questions by a judge, and his incredible rationales for his actions. Both magistrate judge failed Bean and fair administration of justice below when they failed to follow up numerous obvious red flags as to Bean's competency to represent himself at trial. In similar circumstances, this court has found the defendant incompetent to represent himself or has deferred granting the right of self-representation pending a mental competency examination of the defendant. For example, at the Feretta hearing, the judge described Bean's assertions as nonsense, and Bean was unable to answer several of the judge's questions. At the hearing on his motion to dismiss, he not only demonstrated a lack of basic judicial procedure, but could not explain to the court the grounds for the motion. His incompetence only became clearer as the trial began. There being made delusional statements throughout the proceedings based his defense on a massive conspiracy theory and struggled to answer basic questions, although the court continued to describe Bean's statement as nonsense and fantastical, took no steps to investigate his competency or impose other safeguard. Trying Bean with his co-defendant Tushy Giraffe compounded the prejudice to Bean. Tushy Giraffe had formerly represented herself as Bean's lawyer, and he had relied on her legal advice in conducting the transactions underlying his charges. The court admonished Tushy Giraffe that she could not represent Bean on multiple occasions, but that was insufficient to protect Bean. Trying the defendants together compromised Bean's ability to properly communicate his level of culpability and lack of intent to the jury, since Tushy Giraffe frequently undercut his lack of intent in order to protect herself. Let me restate that. Tushy Giraffe frequently undercut his lack of intent in order to protect herself. Randy is blaming Heather for throwing him under the bus to protect herself. The two collaborated on their defense, but Tushy Giraffe frequently took the most advantageous positions at trial to Bean's detriment, convincing him to present his opening statement and case in chief first at the last minute, even though he needed more time to prepare. The court's warnings indicated that it saw the prejudice Bean suffered, yet took no steps to protect Bean beyond pointing out the problem. The trial court abandoned Bean to his own devices and to the whims of his co-defendant without assuring himself that Bean was competent to handle his own defense. The court's decision ultimately led to Bean's fundamentally unfair conviction. Then there was a discussion of the case law, discussing self-representation. I'm going to skip that. The transcript of the hearing reflects that Bean was incapable of answering basic questions posed by the judge. We shortly asked Bean whether he was God. Bean replied, "I am the source of all that is." He asked whether Bean was the source of the sun and the moon. Bean responded, "I am the source of all that is." The magistrate simply moved forward as if nothing bizarre had happened. The October 18 Presby hearing offers another example of Bean's incompetence to which the court failed to respond. The court noted that Bean subscribed to the theory that, among other things, the United States is a corporation, the United States government no longer exists, the law no longer exists, the only authority over Bean was that over which he consented, that the courts are the functional equivalent of banks, that judges are bank tellers, and that he could cancel the indictment by writing void across each page. Clearly, Bean lacked a basic understanding of the American legal and political system. More than that, Bean lacked an understanding of his own case as presented by his co-defendants. During the October 18th hearing, Bean could not explain the precipice to dismiss or the basis for claiming that the court had no jurisdiction over him. Bean also argued in detail that his case involved a massive global conspiracy aimed specifically at him. At trial, he relied on the argument that this massive conspiracy included General Guanzhong Wang of the People's Liberation Army, Putin, high-level cabinet officials, the Italian version of Jeff Sessions, Bill Gates Sr., and the English Rothschilds, as well as the Swiss and French Rothschilds. Are there Swiss Rothschilds that are different from French and English Rothschilds? Well, anyway, he alleged he was kidnapped on several occasions to keep him quiet. Throughout the proceedings, the court referred to Bean's statements as nonsense and fantastical. Then there's more stuff about case law. There's a good quote here from law scholar John F. Decker. Considering the stakes involved, one must consider the wisdom of permitting persons to enjoy the right to shoot oneself in the foot, particularly when the policy behind the Sixth Amendment is protecting the trial interests of the accused. In other words, by allowing Randy to represent himself, the court gave him the right to shoot himself in the foot. This is the juicy part of the argument. Bean's self-representation was particularly inappropriate when his co-defendant and alleged co-conspirator was his former attorney. The criminal prosecution Bean faced fell below the standard of fundamental fairness required in a criminal adjudication. His case was prejudiced by the joinder of his case with Tucci Giraffe's case. Bean did not move for severance, which allowed Tucci Giraffe to influence his case and limit his representation of himself. The trial court allowed this to occur despite its own admonition that at both the defendants that Tucci could not represent Bean. On this record, it would be blinking reality to suggest Tucci Giraffe was anything but lead counsel at this trial. To be sure, the criminal trials of different defendants may be joined in certain cases, but if the joinder of offenses or defendants in an indictment and information or consolidation for trial appears to prejudice a defendant or the government, the court may order separate trial of the counts or sever the trials or provide any other relief. Applying Zafiro, a district court within the Fourth Circuit. Well, let's skip this. Bean's case is different. He and Tucci Giraffe had no previously severed co-defendants take the blame in absentia. Instead, the person upon whom Bean could have pinned responsibility, enabling him to argue that he lacked the requisite intent to defraud, was his current co-defendant and de facto attorney. Let me rephrase that. For Randy to be found not guilty, he would have to say that he was not trying to defraud USAA when he stole and laundered the money. But in order to do that, he would have to put the blame on Heather and Tucci Giraffe because Heather lied to him and manipulated him, told him that what he was doing was legal. But because the court joined their cases, Randy was not able to defend himself and put the blame on Heather. Bean never made a motion to sever. His failure to do so suggests that he was not competent to represent himself. The lower court admonished Tucci not to represent Bean, but the trial transcripts show that Tucci Giraffe and Bean collaborated on this approach on the case. This should not be surprising to anyone. Bean relied heavily on Tucci Giraffe's legal advice prior to trial, though she is not an attorney. There's a discussion. Tushi did say that she graduated from Gonzaga and was one point licensed to practice law. However, it is undisputed that Tushi was not a licensed attorney throughout the time she provided legal counsel to Bean in 2017. Tushi testified she canceled her bar license on March 2011, following her arrest for conduct unrelated to the facts of the present case. That was the arrest at her eviction. Furthermore, FBI agent testified that she was not licensed in the state of Tennessee or in the state of Washington. Tushi Giraffe held herself out to be Bean's lawyer to bank employees and law enforcement. Tushi also signed documents for the Factualized Trust and was listed on the deed for his motorhome. Most significantly, Bean's testimony shows that he relied on Tushi's legal advice to determine that the funds he withdrew were his own. In light of Bean's detrimental reliance on Tushi Giraffe's counsel and potential prejudice, the court would have been justified in severing the trials. Moreover, Bean exhibited a strong loyalty to and trust in Tushi Giraffe. Bean stated that he was enamored with her and felt that he had much to learn from her about this widespread corruption. Which is one of the interesting things about this whole OPPT thing, the way that Heather is able to sort of brainwash people. So essentially making this a cult. From Bean's perspective, why would Bean seek legal counsel from an attorney without this sort of specialized knowledge? This paradigm created a situation where Bean's most trusted source of counsel throughout his criminal trial was also his co-defendant. Bean's conduct demonstrates detrimental reliance on Tushi Giraffe. Bean was in a disadvantaged position because of Tushi Giraffe's legal training. Bean stated early in his testimony that they decided at the last minute he was going to go first, so he was going to have a little more time to get ready. The court was aware of the risk that Tushi would attempt to serve as Bean's counsel, blah, blah, blah. However, no matter what the district judge said, Bean's reliance on Tushi Giraffe remained strong. Bean relied on evidence that Tushi Giraffe unsuccessfully attempted to introduce. He trusted her knowledge of the Uniform Commercial Code, which he did not pretend to understand. He trusted her knowledge of trust, including for the trust he put in his own name. Bean almost blindly followed her instructions, followed his instructions, her instructions, going so far as to put his thumbprint with red dye on document as his energetic signature. Bean relied on Tushi Giraffe despite the fact that her conduct at trial tended to prejudice Bean. In her testimony and examination witnesses, she presented herself as playing a passive, merely supportive role in the scheme and her relationship with Bean rather than one as his chief advisor and instigator. But let me read that again because it's a big sentence. Bean relied on Tushi Giraffe even though her conduct at trial tended to prejudice Bean. What Heather was doing during the trial was screwing over Randy. In her testimony, she presented herself as a passive, merely supportive role in the scheme, rather than one as she was the chief advisor and instigator of the whole thing. Which, sort of going back to Heather's appeal. Heather's defense is that she's crazy. But if you want to be cynical, her conduct during trial indicates a little bit of sanity and intelligence because she was trying to screw over Randy and get herself off. In one instance, Tushi Giraffe stated her actions were based on the actions that were done against Bean. In Tushi Giraffe's cross-examination, she attempted to disassociate herself from him and highlight areas where she did not counsel him. Furthermore, Bean relied on Tushi Giraffe despite the fact that her testimony had little basis in reality. Tushi Giraffe claims to be a high-level intelligence official. She's not. Who believes her conduct, as well as Bean's conduct, were part of a war. Referencing that war, Tushi Giraffe said in her opening statement that actions were taken in July to be able to mitigate, if not terminate, that particular threat against people in America as well as around the world, and it was in connection with the threat that was being made against the President of the United States, Donald Trump. Tushi Giraffe also stated that the present case eventually brought her to Texas to deal with the Bush family because of the unlawful interaction between the FBI and Bean. Indicated that the highest levels of the military were involved. should probably say that the FBI and the military are different things. So that's a nonsense. When Tucci Giraffe stated that she believed her orders in this cleanup came from Commander Thorak, the government was quick to point out that he is a fictional character from World of Warcraft. Notably, Tucci Giraffe argued throughout the trial that there was a meaningful distinction between representing oneself as an attorney and representing oneself as a lawyer, arguing that many people don't know the difference. Tucci suggested an attorney must pass the bar and be licensed, while a lawyer can be licensed. The DOJ never had licensed bar attorneys in there. They were just always attorney. That is not true. Tucci Giraffe stated at trial she was being lawyer throughout the underlying transactions. Tucci Giraffe made every attempt to show that she did not act as an attorney in order to justify her actions, but admitted at trial that even she had described herself as being Bean's attorney in some instances, and there was video of Heather calling herself Randy's attorney. So that is nonsense. It should be noted that Bean adopted Tucci Giraffe's odd distinction between lawyers and attorney. Finally, conclusion. This got a little bit too long. I should have skipped more stuff. This is a deeply troubling case. As Justice Jackson noticed long ago, a co-defendant in a conspiracy case occupies an uneasy seat. There generally will be evidence of wrongdoing by somebody. It is difficult for the individual to make his own case stand on its own merits and make minds of jurors who are ready to believe that birds of a feather are flocked together. And I may imagine that individual in that same uneasy seat without a lawyer because he is proceeding pro se, despite a plethora of reasons for questioning whether he's competent to do so. And finally, imagine that the individual's co-defendant, whom he trusted and was enamored with, is proceeding pro se right alongside of him, despite potential competence issues of her own. What is a jury to make such a three-rank circus? Guilty as charged, justice here. For unknown reasons, the court did the minimal amount of work necessary to inquire into Bean's competence to represent himself at trial. Bean's difficulty at trial were also compounded by the fact that his co-defendant, Tucci Giraffe, was tried with him, was also proceeding pro se. Our research has not uncovered any other case where two conspiracy co-defendants have been tried together, which each proceeding pro se. Of course, as Bean was represented by counsel, he could have filed a motion for severance, but with no legal training, Bean never did so. Any impartial reading of this record can only leave one to wonder why Bean was deemed competent to represent himself, and that was something people were wondering about. Why Tucci Giraffe was deemed competent to represent herself, and why they were allowed to do so in a joint jury trial. Trial court judges have a trial to protect the rights of individuals. They failed to do so here. As a result, Bean's conviction should be reversed, and this case should be remanded to the district court for further proceedings. Key point to point out here. Conviction being reversed doesn't mean that he's off free. There's a retrial, and he would have his own trial without Heather representing him. Also interesting to point out that Randy's attorney is not claiming that he's mentally ill, simply that he is ignorant of the law and didn't know what was going on and was being brainwashed by Heather. Finally, keep in mind here, this was filed December 5th, 2018. The OPPT HATJ crowd has kept this secret for about 3 months because, as you can see here, this indicates that Randy no longer believes that CDA camps are real. He is now blaming Heather for the conviction. He is now admitting that Heather lied to him and manipulated him, brainwashed him, etc. They are not appealing on the grounds that the accounts are real. They have given up on that. They are appealing on the grounds that Randy and Heather weren't competent. Heather was incompetent because she suffers from mental illness, and Randy was incompetent because he didn't understand how the law works in this country, and because he was being brainwashed by Heather and believed that Heather was a competent attorney when in reality she was not. So we'll see what happens with this. It looks like Randy and Heather will get a new trial.